We turn now to the rules that determine what constitutes performance of an enforceable contract. This screencast lecture introduces the topic of substantial performance. The UCC rule of perfect tender allows a buyer to reject any performance that fails to conform precisely to the specifications of the contract. Even an utterly trivial difference that no sensible person would care about can justify a refusal to accept the goods. For example, a car delivered with tires of equivalent or even superior quality, but a different brand name, would be a failure of perfect tender. In contrast, the common law rule of substantial performance allows a court to determine whether the defect is trivial and innocent. If the promisor's breach is not willful and the defect is insubstantial, then a court can limit the promisee's remedy to monetary damages for any resulting difference in the value of the performance. As you saw in Jacob and Youngs against Kent, the practical effect of the substantial performance doctrine can be to eliminate any claim at all if the promisee can't prove a difference in the value of the performance. The parties are likely to bargain to the same allocation of risks under each of these rules. So how should we decide which one should be the default? In Jacob and Youngs against Kent, Judge Cardozo argues eloquently in favor of adopting a majoritarian rule. He famously says that intention not otherwise revealed may be presumed to hold in contemplation the reasonable and the probable. Cardozo reasons that the builder's use of non-Reading pipe was not willful. The other pipe is just as good as the Reading pipe, and most reasonable people wouldn't care which pipe was used. Thus, the defect in this case is both innocent and trivial. This satisfies the doctrinal requirements to apply substantial performance doctrine. Judge Cardozo also concludes that the general contract clause requiring the builder to tear out and replace any non-conforming work is too broad to be taken literally and applied to every defect. So the owner gets damages only, which here are negligible or nothing. The dissenting Judge McLaughlin responds that the contract should be enforced as written. But why? What concerns motivate him? McLaughlin questions whether the builders have performed in good faith, because they've offered no explanation for their failure to perform. The concern here is that contractors have an incentive to substitute cheaper or lower quality materials on the sly. We can call this practice contractor chiseling. So perhaps we need a rule of perfect tender to police against contractor chiseling. But we should also consider whether there might be a problem with owner incentives under the perfect tender rule. Judge Cardozo could reply that a perfect tender rule creates a problem whenever it would be incredibly costly for the builder to correct an innocent and trivial defect, like the pipe brand or the source of the foundation stones. This rule potentially invites the owner to demand a large price concession from the builder in exchange for excusing the trivial defect. We can call this a problem of owner extortion. There exists a real tension between these competing incentives for contractor chiseling and owner extortion. How can we decide whether to use perfect tender to address contractor chiseling, or instead to adopt substantial performance to deter owner extortion? Let me sketch here a somewhat complex argument for using a substantial performance default rather than perfect tender. For complex construction or other service contracts, there's always a risk that the contractor will deviate innocently from at least one of the many specifications. Sometimes deviations will affect significantly the owner's utility or enjoyment of the building, and if so, the builder has to fix the problem. But frequently the deviation will have a trivial effect, and even a trivial deviation can be incredibly expensive to fix when it's discovered. For example, the wrong pipe or the wrong stone for the foundation. Under perfect tender, the owner has the contractor over a barrel. The owner can demand replacement or a payment just less than the cost of replacement to settle the owner's claim for breach. In effect, the owner gets a free house or maybe a dramatically cheaper house. Thinking about the matter at the time of contracting, ex ante, the owner and contractor both realize that this lottery ticket must cost something. The contractor is not in the business of running a lottery. He just builds houses. And the owner's not in the habit of playing the lottery. He just wants a house. So a well-designed substantial performance rule reads the specs in light of the reasonable and probable intent of the parties. In Jacob and Young's against Kent, the contractor does not appear to have been chiseling. The other pipe is just as expensive and of the same quality. It looks like an innocent error due to inattention. At most, the builder was negligent. The owner does not appear to have had any special desire for Reading pipe. If anything, the owner looks to be taking advantage of an inadvertent error in order to pay substantially less than the contract price. Thus, most parties would want the court to apply the substantial performance rule to this case and others like it. This approach tries to do justice in the individual case. In this case, the owner's demand is probably unjust. It also reduces the cost of construction contracts because it eliminates the lottery ticket. And finally, it saves most parties the cost of specifying the complex rule of substantial performance in their contracts. So substantial performance tries to eliminate owner extortion, while still guarding against willful breaches that might be evidence of chiseling. It's thus another compound liability rule that includes elements designed to create good incentives for both owners and builders. But also note that it's a somewhat indefinite standard rather than a precise rule. The cost is greater uncertainty about contractual obligations and an additional burden on the courts. The substantial performance doctrine is not helpful if courts frequently get it wrong. But remember what's at stake here. Anyone dissatisfied with the default rule and willing to pay the price can bargain around it to get perfect tender, or any other rule they want. Against the background of this default rule, parties to construction contracts have worked out a careful set of compromises to balance competing incentives. To deal with opportunism on the part of contractors, specifications typically provide explicitly for the substitution of equivalent materials. They also include reasonable allowances or tolerances for deviation in the placement of walls and fixtures and so on. The specs will sometimes say, use brand X, no substitutions. For example, where a school system stocks replacement parts for only one brand of door hardware or light fixture. Contracts often require so-called material data submissions from contractors, itemizing exactly what materials they will use. To deal with opportunistic owners, the contracts provide for regular inspections and approvals of each phase of the work, and for progress payments. But the problem of inadvertent and latent defects still exists. It sometimes leads to litigation. But most construction contracts today provide for arbitration before a panel of industry experts. The parties hope to reduce uncertainty by using knowledgeable insiders rather than generalist judges to resolve their disputes. Thanks for listening.